Because if you haven't and there is a claim against that entity, a judge could see it as an abuse that you undercapitalized it or you're not really running it as a business. It's really interesting because there are more sophisticated planning strategies now in 2024 than there ever have been, but you still see people using these incredibly antiquated, out of date, and really just bad strategies that don't give them asset protection whatsoever. If anything, it's opening them up to other levels of asset protection, scrutiny, or the ability for personal creditors or other creditors, and I'll explain what that means, to penetrate those assets. So in general, the idea with asset protection, the best idea is that you want to structure entities and trusts to be able to protect your assets. We do this by changing the nature of legal ownership from you as an individual to something else, the entity, the trust, or both, right? We give you control and we give you benefit of those assets, but you technically do not own them. What we see a lot is that clients, business owners, otherwise understand this concept that they need to get assets out of their individual name, but what they do is they put other individuals on title or give them ownership of their assets. Maybe it is putting the name of their business or their other assets in the name of a spouse, or maybe it is an elderly parent, or maybe it is putting an elderly parent on a joint account or joint ownership with the client on some type of asset, or the spouse, or maybe a child, or whoever it may be. The problem is they're not really changing the ownership enough to protect the assets, because again, an individual is related to it, and maybe even their own name is still on it. So we'll kind of talk about a few different things of why this is an issue. Perfect example, and I think an easy example, is that example where you're putting a spouse on an asset. I think probably you can guess, a divorce could happen. Divorce happens. That asset, even if it was a business asset that the spouse whose name is on it never had anything to do with it, if that now occurs while there's a divorce, then that asset is technically that spouse's asset. It could be subject to the marital estate, and it depends on the laws of where you live and all that, and how that would play out. But point is, that is an issue. Okay, that's kind of a more straightforward issue. Let's talk about a parent or a child that you put on accounts with you, or put their name on ownership of a business or otherwise. Few things could happen. One, let's just say you have that elderly parent who you've moved a brokerage account to because you want to protect that. Well, that elderly parent, a few things. One, maybe they need Medicaid, they need public benefits, they need to apply, and they can't now because they're no longer eligible because they have this large brokerage account or other asset in their individual name. Okay, that's one issue. Another issue is, let's say that they die. Okay, how is that handled? What is the transition of that asset that you put in their name? Where does it go now? Does it go back to you? How does it get back to you? That's an issue. Okay, maybe even better example, focusing on this legal risk, is, let's say that elderly parent is becoming demented. Dementia is coming, Alzheimer's coming, we don't know. But maybe they're still on the streets. Maybe they're still driving their car, and you haven't really figured out what's going on with them yet. But maybe they run a red light and they kill someone by running that red light. If their name is on any asset, that asset could be subject to their personal creditors. So now all of a sudden you put a brokerage account in their name, or maybe a business interest in their name. Now they have creditors that could go after those assets that you were trying to protect. Same thing with a child. We see that all the time. A child, maybe they're 21, 22, just a young adult. They're living their life, but they're probably a little more reckless than you would be. Same thing could happen. If you put their name on an asset, any of their creditors could go after it, and you don't want that. You're opening yourself up to a whole nother level of potential creditors by putting other people's names on your assets. If your whole goal is to get your name off of assets, why would you put them in the name of someone else? That's not what you want to do. So you got to figure out other things. So what are some good strategies? Malpractice insurance, an umbrella insurance in general, right? Make sure that you have adequate coverage. Now, insurance doesn't always cover everything. A claim could fall outside of that policy. So that's why it's important to have other strategies, such as making sure that you have the right business entities like LLCs and asset protection trusts. With an LLC, really quickly, you want to make sure that you're running that properly. So just because you have an LLC doesn't mean that it's foolproof. You got to make sure that you're following all the corporate formalities that an LLC should follow. Are you having annual meetings? Are you updating minutes? Do you have separate books? Do you have clean books? Have you properly capitalized that entity? Because if you haven't and there is a claim against that entity, a judge could see it as an abuse that you undercapitalized it, or you're not really running it as a business, and say, hey, we're going to pierce the corporate veil, as it's called, and we're now going to go after your personal assets. So there's all these different things that you have to look at and make sure that you do correctly. But at the end of the day, the worst idea that you can have is just keeping assets in any individual's name. You want to make sure that you're creating structures that others, other than individuals, are owning these assets, but you have beneficial interest and enjoyment of these assets, and you're retaining control. So don't put assets in other people's names.